Right, good afternoon all. You can see we've got people joining online, that's great. What we'll do is we're going to run through some bits and pieces today. If you've got any questions, please do pop them up in the chat, or at the end if you'd like to unmute and ask directly, then Steph and I can seek to answer those for you. But I think we will make a start as we've got people in. So today we're going to talk about the Court of Protection and the sorts of applications that one might bring within the Court of Protection for deputyship orders, statutory wills, orders relating to gifts, and indeed health and welfare orders and applications. I am Graeme Black. I'm a partner in the private wealth and inheritance team specialising in Court of Protection work. And this is my colleague Steph, who's a CILEX lawyer who also works alongside me and deals with the same sorts of work. So we will begin by looking at a bit of an overview of the Court of Protection and what it does and what it stands for and why it exists. The first comment we have in there is jurisdiction. The Court of Protection deals with matters within England and Wales and is exclusively for the use of matters relating to those people where those situations where people do not have capacity. They have lost capacity, whether that be mental capacity to make or understand a decision or physical capacity to be able to communicate that decision. We're aware of illnesses like motor neurone disease and locked-in syndrome where people can still retain their mental capacity, but you lose the use of their faculties to the extent that they cannot communicate any longer. So the Court of Protection, England and Wales, and relates to issues relating to capacity. We've also said, what is the difference between the Court of Protection and the Office of the Public Guardian? Well, as I say, the Court of Protection deals with those situations where individuals have lost their capacity, whether it be mental or physical to an extent. The Office of the Public Guardian is the body which regulates lasting powers of attorney and old enduring powers of attorney, arranges for those to be registered, and will sometimes bring a case to the Court of Protection if there is a conflict between attorneys. But really the Office of the Public Guardian is related to those documents which have been prepared by individuals who have capacity when those documents are prepared or are believed to have had capacity at that time. It is called the Court of Protection. There is a question there, do I have to go to court? For the vast majority of applications, one does not need to attend the court physically. They do have court premises in London and in Birmingham, but generally one doesn't need to attend court. Most of the applications within the Court of Protection are paper applications. They're dealt with by way of very prescribed forms, capacity assessments and correspondence, but they do go in front of a judge. There are times when one will need to go to court where there is a disagreement about the route forward, about what is in the best interests of the individual whose affairs are being looked after or being proposed to be looked after. We can have people complaining or objecting to who the particular deputy is, and maybe arguing that they should be the deputy. There can be decisions around financial and indeed physical health and welfare elements where the court will be required to make an intervention. We'll cover some of that later on. So in general terms, one does not need to go to the court, but there will be occasions where attendance at court is required and a court hearing will be had, usually with barristers or solicitors of higher rights of audience. And then applications generally, the Court of Protection is very much an applications court. It is, as I said above previously, it is to do with paper applications. It is dealt with by correspondence. If they have a question, they will normally write or email rather than phone or ask you to attend court. So it is an applications-based process whereby an application is made to the court for their consideration. A judge will consider that application and the extrinsic evidence, and at that point then the judge feels as though they have sufficient information to make the decision, or they do not, in which case they'll ask for more. And it is, as I said about earlier on, it is rare that they will ask for an attendance at court, but they will do that periodically where they would like to get some more information around the individuals concerned or the nature of the decision making that's being undertaken. So that's a brief overview of the Court of Protection and its role within that sort of the capacity area and the applications that one might expect to be proceeding with. And I'm going to hand over to Steph now, please.
Right, so there's different types of applications that are made. Graeme touched on the differences between the Court of Protection and the Office of the Public Guardian. So you can have, there's obviously the differences between lasting power of attorney and a deputyship. Some people think that if you have a lasting power of attorney that you never have to apply to the court of protection. And unfortunately, there are some cases where you still need court of protection approval for some of the decisions you make as an attorney. So here we're just covering more of the applications where there is no power of attorney. But it's just to bear in mind that sometimes you do also need to do both. So on the slide, there's a list of different ones as to where applications are needed, where there's no power of attorney, any decisions made in regards to properties, that's buying or selling, any investments, big investments being made, there needs to be authority from the court protection. And yeah, there's a long list there. Health and welfare is much more difficult in totality when it comes to court protection. The courts are more careful as to decisions because obviously your health is more important. So they are arguably more concerned about that. But every form of decision needs approval, essentially. You can get an application, you can make an application at the court protection to be a deputy for property and finances, which gives you the power to deal with most of those things there. Property, they generally are more cautious with, but health and welfare, it's very rare that they will grant a health and welfare order to allow you to just make those decisions in totality. Normally, they're very decision specific with the health and welfare court protection orders. So applications where the property needs to be sold, again, these can be more complicated. A lot of people nowadays all of their assets are essentially in the property. The property is generally the most expensive thing a person will own. So selling someone's property on their behalf is a big thing to do. So there's some points there, like, do you have a power of attorney? As I touched on earlier, just because you have a power of attorney doesn't mean that you can just go ahead and do what you want to do. There are still situations where you can have that power of attorney, but still need to make an application to the court of protection for the property to be sold. The key things to think about are on the slide there. So if there are co-owners, you need to look and see, is one of the attorneys the co-owner? Is there a conflict of interest there? Who is the property being sold to? Is it being sold to, again, one of the attorneys, a family member? The value of the property being sold, is it the market rate? How long have we had it on the market for at that rate? How many times have we tried to drop it? Is there a mortgage? There's a lot of things to consider essentially when we're selling the property. And if you have a property and finances court order, as I said, you need to make sure that the order does state that you have the authority to sell the property. Otherwise, you will have to reapply to get that authority from the court.
And just on that final point, if I may, it used to be that when making court of protection orders for property and finances, we would put in the application that we would like the authority to sell the property belonging to the person in question, and they would usually just put in a provision that says that the deputies can deal with the property belonging to the patient. Since about 2.5–3 years ago, there has now been a requirement when making those applications to demonstrate that the individual is, depending on the exact nature of the order being sought, subject to a deprivation of liberty safeguarding assessment, which will state that they're not going to go back to their own home, and that therefore someone's not going to sell a property that an individual who may have, somebody might be in a coma having had a car crash, but have a prospect of full recovery. And what they're concerned about is the potential for a deputy saying, oh, this person doesn't have capacity, selling that property that the person would want to go back to and would be able to go back to, and then harming in some way their potential for recovering in the way that they would otherwise have done. So they have introduced more safeguarding around these applications where we are trying to deal, well, where we're not, where deputies are hoping to deal with the sale of the property, to make sure that these safeguards are in place and that it's unlikely that the individual will return to the property for any number of different reasons. So that's all been tightened up a bit in the last 3 years or so. So we're looking at also now applications where a medical decision needs to be made. As Steph said, you can apply for a health and welfare order from the Court of Protection. They are more rare than the property and financial affairs order, because the court can understand one's property and finances. You detail bank accounts, building society accounts, income, expenditure, care costs, all of those things go in there. what their income is from their state pension, from their private pension investments and everything. So they can quantify how much an individual has coming in, going out, and what they're worth in pounds and pence. They quite like that. That's quite a comfortable space for the court to operate in. What they are more reluctant to do, despite these orders having been introduced in 2007 under the Mental Capacity Act of 2005, they are reluctant to grant the authority to an individual or individuals to generally manage the health and welfare of an individual. We have more recently been successful in securing some of these orders for young adults who are becoming adult, having been teenagers, but have had very severe learning difficulties and some elements of their ability to make decisions which clearly mean that if they were asked if they wanted to have a flu vaccine, they wouldn't understand the quantum of the question, let alone whether they ought to consent. So there is a slight softening. There are more of these health and welfare orders being granted each year, but there are still not very many at all by comparison. And we do have to say to people that they are much more unlikely, and we're happy to give it a go, and we try and make the drafting as tight as we can to try and have the best chance of success. And we have also recently appealed one where the court didn't give us the order that we wanted, but we have gone back with even more evidence and have asked them to change their mind, and they're looking at it at the moment. But in reality, they are not as likely to be able to achieve as the Property and Financial Affairs order. For them, as I say, the courts don't really want family members making decisions about the welfare of a person, because that's the key thing. Is more important than money in the eyes of the court, and for most of us, I think, on this call probably as well. And we want to make sure that the court wants to make sure that people aren't making decisions which damage the welfare and the well-being of an individual. One of the points on there is the patient deprived of their liberty. As I said, if they are, there's a better opportunity to seek an order for the sale of one's property, as I was touching on earlier. But in reality, this is a decision that the health and welfare deputy can make. They can make a decision for an individual to be placed in a care setting, or indeed to be sectioned if that's required, and make sure that that person is deprived of their liberty. You know, a fancy nursing home, which is £2,500–3,000 a week, still deprives people who are lacking capacity of their liberty. There are still locks on their doors. There are still codes to enable people to get in and out. And sadly, these people don't know the codes and wouldn't remember them if they were told. So they are deprived of their liberty, even though we're not talking about a prison cell. We are talking about really lovely homes on many occasions. So a deputy under a health and welfare application does have the authority to seek that the patient, the individual, is deprived of their liberty. The court are much better at dealing with these health and welfare applications where there is an urgent medical decision to be made. So a decision-specific matter. So somebody may have lost capacity, and that be widely acknowledged. There may be an order in place, whether it be a power of attorney or a deputyship order relating to the individual's property and their finances, and the deputies are told that the individual needs some really urgent surgery in order to prevent them from some form of worsening of a condition. Now, naturally, the patient in that situation, they can't give their consent, and there is no health and welfare order in place because the court have refused to grant it. So the deputies, the proposed deputies, or the family, somebody who is concerned with the affairs of that patient, would then make an urgent order to the Court of Protection, asking for the court to give permission for them to consent or otherwise to whatever the procedure is which is being considered. We've probably heard some of the high profile cases in the press where family members don't want a life support machine being switched off, or they want somebody to have the machine switched off. You know, those sorts of things, you know, very black and white end of life thing, not so much a foot being amputated because it's gangrenous, or somebody's suffering with diabetes and they may need some further treatment. But those are the sorts of key specific decisions that the court are pretty good at doing, and they're quite good at responding to those in an urgent way because they understand the urgency around those applications. So while it is possible that one may not get a broad health and welfare order from the court, one can get routinely those orders which enable the individuals who are trying to care for that person the opportunity to make those decisions, communicate those decisions to the medical practitioners based on what they understand the patient would have wanted. Now that's not the same, but it's a middle ground, and it's one where the court feel more comfortable, and it also means that the individuals making those decisions, they can seek the advice that they need, they can make the application to the court, they can make that decision, and then they go back to managing if it's the same people, the property and the financial affairs. And then next time there is an urgent health requirement, if they need to make another application, they do. The worst part being that there are multiple court orders and multiple fees to the court, but they do respond pretty quickly on those urgent bases where required. And then one of the reasons that they're not particularly keen on granting a broad health and welfare application to individuals, even if they are medical practitioners, is the deputy qualified to make a decision, right? As lawyers, Steph and I are not qualified to make decisions around somebody else's end of life care, whether they be our family or not. It's not our qualification. We work in this space, but we do not know the nature or the extent of the illness or the injury that individual is suffering with. We do not know their likelihood of being able to make a full or partial recovery. We do not know the extent to which they will end up being able to regain their dignity, which is a really big thing for people these days, of course. So we don't know. We are not qualified, and that is one of the reasons that the court make these applications a bit harder to obtain, because they acknowledge that people are not qualified to make those decisions. Where there has been a bit of a change, as I said previously, is that these young adults becoming adults, where mum and dad have maybe been able to attend all of their school meetings, all of their medical meetings, help them to take their medication, whatever it is that the conditions that they have, and they turn 18 and they're no longer allowed to attend those medical appointments. That becomes a concern, where that young man or young lady is presented with decisions that they cannot comprehend, where their well-being will be adversely affected, significantly adversely affected, by not being able to understand what is asked of them, and therefore not being able to communicate or consent or refuse consent, if that's appropriate, to that which is being asked. So there has been a bit of a change in that space, and that there are a couple of those orders coming through. We've worked on a number of those recently, where some of those orders are forthcoming, and that's a good thing, because naturally mum and dad, if they're the right individuals, or mum or dad, need to be in those meetings to be able to help that young person through those decisions, because without those treatments being effective, their condition can worsen very greatly, very quickly, and it may end up leading to their death. So there are a few more coming through, but as I say, not commonplace, not widespread. Another application one can make in the Court of Protection is that for a statutory will. So what is a statutory will? It is a will that is put in place by the court for an individual who does not have capacity. Now, as lawyers, as trainees, as students, we are all taught that in order to prepare a will, the testator, the person preparing the will, must have capacity. We can't do a will without the individual having capacity. And this is somewhere where the Court of Protection can intervene. So they will want to know whether there is an existing will. That is absolutely right. They will want to know, why is a new will necessary? And you can see the questions on there. If there is no existing will, why are the intestacy rules not appropriate? And then what are the changes that are being requested? And I'll cover the last two in a moment. What does happen more and more these days is people become unwell younger. They may suffer with some, horrific injury, a bleed on the brain, leading them to lose their capacity. They may have a life partner, they may have children together, and there is no will in place because they're in their 30s and 40s and they thought it was unnecessary. In reality, if they were to die in that situation, their life partner would most likely inherit nothing, subject to how their assets are held, whether they be joint assets or not, but they would not inherit anything of that person who suffered this horrific injury. The children may, but there would be nothing that goes to the life partner. And that being the case, there are a number of situations where people make an application to say that it would be the right thing, it would be what that individual would want, is to make sure that their partner is looked after, whether it be by way of some form of a life interest in the property, they're allowed to continue to use the property, whether they left everything to then continue to bring up the children so they don't have to work. So those are scenarios which happen. there is the unending number of situations where statutory will applications are made and approved, and they are really powerful in terms of, yes, inheritance tax planning. The court will allow a will to be made to plan for inheritance tax. It may be that because there may be an old will that was made before the changes to the transferable nil rate bands and the residence nil rate bands and the transferability of the residence nil rate band, which maybe have some form of trust or something which would otherwise create a greater inheritance tax liability on the death of that individual. The court will allow a will to be drafted which sets that right, as long as the beneficiaries are not broadly being changed. There was also a need sometimes to change a will because an individual may have had a falling out with a relative, and before they became unwell, that relative was back in the fold, and the family know that the patient would want that relative to inherit, and the family are all in agreement, and they change it during the lifetime of the person who's lost capacity to make sure that the individual who's come back into the fold is now being looked after in the way that the person who's lost capacity would want. So any number of potential scenarios. They do require a court of protection application. They do require extensive form filling. They do require the provision of the draft and the planned will to the court for them to approve it. They do require a copy of that signed will also being submitted, and they're not always approved because sometimes people may be applying for spurious reasons, right? It might be the son saying, "Oh, Dad would have wanted everything to come to me," completely ignoring the fact there are daughters and a mother and whoever else. But as part of the process, it is required that anyone who is adversely affected by the provision of a new will would have to have notice served on them, and the court would need to see evidence of that notice having been served. So one of the questions on our slide is that if there is no existing will, why are the intestacy rules not appropriate? The intestacy rules are inappropriate when it comes to married couples who don't own their assets jointly and they want to leave everything to each other and then to the children, because there is often going to be a charge to inheritance tax on the first death. So you would look at the intestacy rules and say, well, actually that's not appropriate because there's going to be a significant charge to inheritance tax, and you prepare a will through the statutory will process that leaves everything to the surviving spouse and then to the children potentially. And the court will look at it and ask whether the surviving spouse and the children have all been notified, who would be the beneficiaries in any event, and they have been, and they all consent because they can see there is value in it for them in terms of inheritance tax position. It can be that other people who would otherwise have inherited under a will have died or have moved on or they've lost contact, and they may be able to be served notice with in order to update and refresh a will. You would not go through this process just for changing a gift of £5,000 or £10,000, or because mum or dad decided they didn't like a charity anymore that they were leaving a small gift to. You wouldn't do it for this. This is not appropriate for that. The court, A, probably wouldn't approve it, and B, the costs would outweigh the benefit to the estate overall. So there needs to be some good cost savings in terms of inheritance tax, or actually just that moral saving, making sure that the assets are going where the family would want them to go based on the will that's being prepared. So we do lots of those applications. They're interesting. They're not straightforward again, and they require evidence that the patient has lost capacity and isn't able to consent to the preparation of the will.
Okay, so just looking at gifting, as we touched on earlier, when you are a deputy under property and finances, obviously you're in charge of the money, the house, and the authority that is required for making gifts is sometimes you need that authority when you think you don't, essentially. So even if you are an attorney under power of attorney, you have the authority to make those gifts, but also you can't just be making gifts left, right, and centre just because you fancy it. The gifts that you are making when you're in charge of someone else's property and finances should be the ordinary gifts that that person was making and would make had they had the capacity to do so. So, for example, if I were gifting £10 a month to a charity and you continued making that donation, that's absolutely fine. If I were gifting £200 a month to my mum and you continue, that's absolutely fine. If all of a sudden we started gifting £20,000, that's obviously a large difference, and that wouldn't be as accepted. We need to look at the size of the gift in comparison to that person's estate as well. So if my estate is only worth £10,000 and I'm gifting £2,000 every couple of months, it's obviously not going to do me very good things in the end. Why is that gift required? Is that gift actually required? Why are we making that gift? And again, it's just going back to the point of, would that person have made that gift if they did have the capacity to do so? That is the important part. You are acting on behalf of them. And if you are the attorney or the deputy, then obviously you can't really be giving any gifts to yourself. And if you are, then I would highly recommend you get the authority from the courts before doing so. Because obviously that's quite a conflict. I understand that often they are your family members and they would generally give some of that money to you, but it's better for yourself that you get that authority.
Yeah, I think some of the other applications, I think that's the end of our slides, isn't it? I think the next one is, are there any questions? Yeah, so I think the only thing to finish off on is one of the things that we have done quite recently is make a retrospective application for permission from the court after some attorneys had already acted in the sale of a property at what was perceived to potentially could have been regarded as an undervalue based on the valuation that was provided at the time by the estate agents. Fortunately, there was lots of extrinsic evidence that showed how much the property was actually worth and the offers that had been received. What made that one particularly complicated to try and get through the court was that it was one of the attorneys who had bought the property at what was then at that point regarded as the market rate, because there was pressure being brought to bear by the home that the property had to be sold in order to fund the care. Otherwise, they were going to start charging, penalties and significant interest, and the family felt under pressure to act. So we were able to, after much drafting and much work, we were able to get that retrospective permission from the court that they approved that transaction did take place of the sale of the property of the patient to one of the attorneys at what could have been perceived to be an undervalue. But as I say, all of the correspondence with the estate agents, the offers that were made, all pointed it to it actually being at the market value. But I would always please don't ask us to do those retrospective applications. We would be much better off doing anything like that in advance. In this particular situation, there wasn't time to have that done, and we were only asked to act after it had been done. So those are the sorts of applications that, it's a bit of a flavour of the things that happen in the Court of Protection, what it's there for, why it exists. And if there are any questions, we'd be very, very happy to take any. You can either type them into the chat, which I don't think I can see at the moment, but Toby might, and or unmute and ask away. And we'll wait here for a couple of minutes to see if there's anything else. And in the meantime, we'll put some information about us, because that's who we are. And thank you all for joining us this afternoon. Oh, muting is disabled, so I'm going to ask anything. Okay. Can we unmute?
No, it's the way it's set up, unfortunately.
We're happy to take questions in the chat. So I'm sorry, I didn't realize that people couldn't unmute. Apologies. Question coming in. Rebecca's typing a question, so we'll try and answer this for you. Right. So, question, Rebecca, thank you. A young person with significant complex needs who ever had capacity and is cared for by the parent in terms of their finances, would they only receive benefits and disability benefits, etc.? Is an appointee enough, or would they need deputyship for their finances? Sorry, hope that makes sense. Yes, absolutely, that does make sense. So really what we're talking about is the situation where you have a young adult or younger potentially, and due to the nature of their potential illness, they may never work, they may never be employed, they may spend their life on benefits, which will be whichever benefits are applicable. And yes, an appointeeship, being an appointee for their benefits is absolutely fine. The complication comes where and if later in life they start to receive money, whether they receive money from grandparents or whether money is put into some sort of a trust because the family know that if the money is paid directly to that individual, it may affect their benefits, and they want that money to be able to work to make sure that they have access to the best care or some great experiences or whatever it happens to be. And at that point, it can make it a little bit more difficult in terms of actually accessing those funds to make sure that you are dealing with those on behalf of that young person who at that point obviously naturally wouldn't be as young as they are. So an order from the court may be appropriate later, if not at this point. And I can see that Rebecca is adding, and I think that great. Thank you, Rebecca. If you have any questions, obviously our details are there. We're very happy to try and help wherever we can. And same for any of you. And I think Shahid is also typing potentially a question, so we'll hang on for that as well. It's good to have questions. Sometimes we do these without questions, so it's quite nice to be asked and know that people are listening and that we can try and do something to help a bit. Just waiting for a couple more questions. Here we go. So we've got a question from Linda. Not sure if this is to do with today. Are you able to tell me if it's necessary to have a DOLS in place for a client that has learning disabilities but is deemed to have capacity, as the door to the home is kept locked as we're near a main road and none of the clients have road sense? Well, this may or may not be for today, Linda. It's a very good question. I think it depends very much on the nature of the extent to which their liberty is being deprived, right? A lock on the front door, where they are able to come and go under supervision, is different to a lock on the front door to which they have no access and are unable to open, without damaging it, without breaking it, and also the reasoning behind the deprivation of liberty is important. So it may be something that would require further conversation. Shahid. Parents fell out with one son and created a living will in favour of the other son, who has since sold the house without consulting his brother. Can the brother do something? The parent has passed on. So that's a slightly different scenario. That's sort of where one child has sold the house without consulting a brother, and the parents have then subsequently died after that, I think is what I'm understanding, Shahid. But so it was done during the lifetime of the parents, and then the parents now passed on. And I'm assuming from the question that the brother who sold the property has retained the sale proceeds, but I'm not certain on that. If that's the case, that's not really a court of protection issue or a capacity issue. That is much more of an issue that our dispute resolution team, in particular my colleague Mike Pollard, would probably be able to assist with some advice on about how that process should have looked and what should have done. Yeah, so it was retained the proceeds, there was no will. So I think that's right. I think certainly not so much for the sort of conversation that we're having today and the work that we're discussing today, but absolutely my colleague Mike Pollard would be able to point you in the right direction and give you some indication as to what the next steps ought to have been or ought to have been during the lifetime of the parents. That I suspect that there are some pretty serious conversations we had around that. So if you'd like to drop Steph or I an email, our details are say on the screen. We can definitely put you in touch with Mike, and I know he'd be able to give you a call to discuss what may or may not be the right thing to do in that situation. I'm sorry not to be able to give you a full answer to your direct question on that. Rebecca also asked, in terms of health and welfare, and once again, a young person has never had capacity to do their complex needs and diagnosis. When they reach 18 and they're entering adulthood, does a health and welfare deputyship need to be obtained in order for the young person to receive medical appointments and vaccines? I believe your slide explained this is the case, but just needing clarification, as I support parents and carers and young children who have significant complex needs. Trying to navigate this is very overwhelming. Yeah, absolutely, Rebecca. That is the biggest issue. Some mental health teams, some community mental health teams, and some care teams in the community and social services are a lot more understanding, and indeed medical professionals. We have come across an increasing number of people who come to us because their child who is turning 18 or has turned 18, and they are no longer allowed to attend those medical appointments, and they are precluded from them. And the child or young adult at that point is expected to be able to make decisions around something which most of us may regard as quite a simple decision relating to a flu vaccine or a COVID jab. And they are incapable of making those decisions. So yes, the only way to guarantee that the parents and the carers will be able to be in those meetings and to have those conversations with the medical practitioner is to get a health and welfare order from the Court of Protection. Now, bearing in mind how I did say that they're not incredibly common, and some of them you have to fight for, and fight quite hard for, they're not a straightforward process. And the reality is that for some of the needs, for some of the young people, their needs can be largely met by muddling along. And we have clients who have children of clients who've got some exceptionally challenging circumstances and exceptionally challenging needs where these orders were not being granted. And as I say, we've had to go back and appeal a couple of these, and some we've received. And that's a real win for those families, because they really want to be involved in those decisions that they are being asked to make, and that young person cannot have any prospect of understanding and making. Now, that is slightly different to somebody who does sort of kind of tinker around the edges, and they may not have such complex needs. But in reality, if the carers, the parents want to and need to have access to those medical appointments with that child, that young adult, unless the medical practitioners are understanding and are happy to engage with them, they may well need an order. It's not the answer anyone wants to hear, but it's just a reality these days, I'm afraid. Victoria is typing as well, so there may be another question. You're very welcome, Rebecca, no problem at all. Can parents from low incomes apply for help with cost of deputyship application? If so, how? So there is a mechanism by which the actual fee can be reduced or not payable to the court, which is single figures of hundreds of pounds. That's not going to go anywhere near the actual, that's not the biggest expense. You know, the biggest expense, if we're being candid, is our time spent on the application, in the meetings and gathering the information and the evidence. So there is a remission scheme, fee remission scheme, which is available for the actual court fee. The work that we do here at Harrington Carmichael, we don't do we don't do legally aided work. There are avenues down which people who have low incomes can go, and that is to apply to the court for a panel deputy to be appointed. I think there are about 60 panel deputies around the country, all in different jurisdictions, different geographical spaces, and they're appointed by the court based on their experience and the amount of work they do in this space, and they are required to take that work on, and that's often at the fixed rates that the court apply, which is still not cheap, but it's much cheaper than using the likes of a regional firm such as us to do something which may be a little bit more straightforward, maybe not straightforward, but can then fit within the confines of the value of what the individual in question has got available to them. So there is an avenue by making an application, Victoria, to the Court of Protection for a panel deputy to be appointed. Now that means that it wouldn't be a family member, it wouldn't be an individual who knows the individual in question. It would be a panel deputy, somebody who sits in a law firm somewhere in the region, but you would be able to meet with them, you'd be able to explain exactly what is going on with the individual if that's required. But there is an avenue. It has its drawbacks, it has its positives, but you could look to explore that if needed. I hope that answers your question. And Shahid is typing as well. Great, thank you, Victoria. If you've got any questions, please do ask. And Shahid, if a person has mental capacity but not physical capacity, for example, to live independently, what happens? So, do you want to see?
If they have mental capacity, they can still enter into a lasting power of attorney. On my initial advice would be for you to look into doing a lasting power of attorney first, getting a lawyer or someone who can assess capacity to come out and confirm that they do have the mental capacity. Lasting powers of attorney are much cheaper, much quicker, and much better documents to use. So they can still enter that with mental capacity. Physical capacity has got nothing to do with either of them, really. They just need to be able to do a mark on the lasting power of attorney, but all of the documents are witnessed, so it doesn't need to be legible or anything beautiful. It just needs to show that they have understood it.
Yeah, cool. So the lasting power of attorney would be ideal if it's achievable in that situation, Shane.
And then with that, you can do property and finances and health and welfare. So our advice is always, if they can, lasting power of attorney is best.
Okay, you're welcome, Shahid. And Deborah says, when a court of protection application is needed rather than a best interest decision made, I'm thinking of patients in hospital following severe disabling injury, for example, related to decision relating to discharge. Is a best interest decision sufficient if all parties are in agreement and the court of protection indicated when there is a disagreement? If person's lack of capacity for that decision, right? So the best interest decision is something we would expect to see in most of these situations. You know, if a person fell over, broke their hip, they were in hospital, then we'd expect to see a best interest decision, regardless of whether there's a power of attorney, a deputyship order, or nothing at all in place, to assess with the medical professionals, social services, the potential carers, the family, to assess what is in the best interest of that individual, Deborah. So we would expect that meeting to happen, and that meeting may agree what is the right thing for that individual. But then the question becomes, if all of those parties agree that it is the right thing for that individual to move, for instance, to respite care, to a home, so that they can get the care that they need, with an apprehension that hopefully they'll go home once they've had that care and they're back mobile, that's great. Who's going to choose that home? Who's going to choose which home it is? Is it going to be a home that's near the family? Is it going to be a home that's near where the individual lives at home? Is it going to be a home that social services have got space in? And that's where it can sometimes become a bit more tricky, right? So where we would, in an ideal world, we probably should have said this at the start, in an ideal world, everyone have their lasting powers of attorney. They would have appointed their attorneys. They will be registered. And if and when a decision needs to be made about care or property and finances, they can be made in conjunction with the attorneys who have the authority to advocate on behalf of that person who has lost capacity. Now, in the event that those do not exist, a specific deputyship order around where that person should reside could be the outcome of a best interest decision, where people cannot agree on where they think the right location is, whether it be because they don't think they get the right level of care, geographically it's in the wrong place, or any number of different reasons. So an application could be made for the court to determine what the right outcome is. No one wants to see that happening. It's much better for these things to be consensual, and most of the time they are. And the problem comes where the parties can't agree. So and once that person is, whichever outcome has happened, that person is then moved into the home. They've had their respite care and it's agreed that they're going to go home. There'll be another best interest decision meeting about what is that person needing when they get home. Do they need a hoist? Do they need rails? Do they need a ramp? Are they going to be in a wheelchair? You know, do they need a bed downstairs? And all of those things. So you would expect these best interest decision meetings to happen regardless of whether the person has a power of attorney or a deputy order, and you would expect the attorneys and the deputy to be engaging fully in those decisions and listening to the professionals, the care professionals, the medical professionals, and making sure that they are then in a position to make the right decision on behalf of the person that they have been appointed to make the decision for. So I don't necessarily separate out a best interest decision as being better or worse than having a power of attorney or a deputyship order. I think all of those things should be, concurrent, should all happen at the same time in the same space. And these things work best where you have concerned family members who have already got the powers of attorney, and you've got people meeting to try and understand what is the best thing for that individual who has become unwell or injured or incapacitated in some way. I hope that answers your question. Perfect. Thank you, Deborah. Good. If there are no more questions, we'll pop off in a while. Thank you very much for your time. It's great to have some engagement. It makes it more enjoyable for us because we're just looking at a screen and our slides, and so we can't see any of you. So thank you very much for joining us. If you have got anything else, Shahid's typing. If you have got anything else, you have got our email addresses and everything else from the previous slide. Feel free to contact us, and we'll reach out and try and help wherever we can. And I'm just going to wait for these last messages. Shahid says thank you, Shahid, and thank you, Rebecca. So enjoy the rest of your day all, and thank you very much for joining us this afternoon. Take care.